Hello everyone, welcome to Module 2 of Business Law. Again, I'm your instructor, Robert Romano, and this week we're going to be talking about the American court system. From the beginning, you need to realize that the United States has two major court systems. There's the federal court system and the state court system. Each are unique, each have their own set of rules, protocols, and whatever. We need to be aware that there's the federal court system and the state court system. Okay? There are 50 state court systems, plus the District of Columbia has their own court system. So there's the federal court system, state court system, each individual state having their own system, and the District of Columbia having theirs. Okay? Court. What do you need to know about court and litigation? Litigation itself. Litigation is the process of bringing in an action to court. Litigation is the process of bringing, maintaining, and defending against the lawsuit. So if I ask you on the quiz what litigation is, you'll say it's the process of bringing, maintaining, and defending against the lawsuit. All right. Three things you need to be aware about litigation. Number one, it is very time consuming. Once you bring a case to court, it's the court that dictates the time, the timeline. So you may bring it and want resolution quickly, but if the court says no, we don't have judges, we're putting it on the calendar for 3 months, we're making it go to arbitration first, it's the court that dictates the timeline. All right? It is very time consuming once you get into litigation because courts are notoriously slow. They're overburdened with cases. Second thing about litigation, it is very expensive. All right, you have filing fees, you have service fees, you have attorney's fees, you have witness fees. All these things add up. And third, it is difficult to navigate through the complex procedural rules within a court. Every court system, the federal court and the state court, have their own procedural rules. And then within each court, they have their own rules, their own ways of doing things. So if you bring a case in Manhattan, those rules may be different from Brooklyn, which are different from Bronx. Okay? So litigation, time-consuming, expensive, and difficult to navigate through the complex procedural rules. State court system. There are two systems within the state court system. There's limited jurisdiction courts and a general jurisdiction courts. Okay? So you have two systems, and then within the state court system, you have two jurisdictional courts, limited jurisdictional courts and general jurisdictional courts. All right, limited jurisdictional courts are just what the name says. They have limited jurisdiction over certain issues. Okay, you know from your readings you have traffic court. You go to traffic court, they're only going to hear traffic tickets or parking tickets. All right, they're not going to hear landlord-tenant issues. They're limited in their jurisdiction over traffic issues. Did you run the red light? Did you use your blinker? That kind of stuff. Juvenile court is another limited jurisdictional court. Juvenile court does not hear adult cases. They just hear juvenile issues. If the child is truant, if the child did something illegal, some custody, limited custody issues. Justice of the peace, probate courts are other limited jurisdictional courts. Probate courts just deal with wills, probate issues. After somebody passes, what to do with their estate. All right, they don't hear anything else. They don't listen to juvenile cases. Can't do your traffic ticket there. Small claims court. Small claims court has limited jurisdiction, not on the issues per se, but on the amount of money is at issue. Okay, so it could be a breach of contract case. Okay, or it could be a landlord-tenant issue. Okay, but you're only dealing with the money issues. And most small claims have a cap, usually about $5,000, $7,000, the amount of the claim. Those are small claims courts. All right, other limited jurisdictional court issues is that evidence is introduced. You bring a case in probate court, you bring a case in small claims court, you do introduce evidence. There is testimony. You have witnesses. They're put on the stand, they're sworn in, and there is testimony provided. However, The difference is there's no record, no transcript. All right, you can get what the court decided as the record, but that's it. You're not going to get a transcript of the proceedings to go through it and say, oh, this was right, this was wrong, that kind of thing. All right. Some jurisdictions, limited jurisdictional courts, the final ruling are appealable. Some are not. Okay, depends on the state you're in, that kind of thing. Okay, general jurisdictional trial courts. All right, we have limited courts. Now we have general courts. They're the courts of record. All right, your criminal court cases, your civil court, they have a record of. You keep transcripts of what happens once you enter into the door and go before the judge. All right, so they are courts of record. General jurisdiction testimony is provided, just like limited jurisdictional courts. Evidence is presented. There is a record, there is a transcript, and the issues are appealable. So if you feel that the district court didn't give you satisfaction, you can't appeal it to a higher court. Okay? Then from the lower court, you have an appellate court. All right, this is where you appeal your cases to. If you're not happy with the lower court's ruling, if you feel that they misapplied the law, you can appeal it to the appellate court. They hear appeals from the trial courts. All right, no evidence is presented at the appellate court. All right, no new evidence. All right, you can't find more facts and then bring it to the appellate court. No, they're only going to review the evidence that the trial courts heard. There's no testimony. There are no witnesses. It's just usually an appellate brief, a written statement of what the issues are, and then argument by the attorneys. Okay? Briefs and oral arguments. No new evidence, no testimony, and they hear the appeals from the trial courts. Okay? You need to be aware the appellate courts only hear issues of law. All right? They will only listen to the attorneys or read the briefs on issues of law to determine if the trial court misapplied the law or determine if the trial court applied the appropriate law. Okay? They're not going to review facts. They're not going to rehear the case. They don't want to hear any more facts. The facts are the facts as far as they're concerned. They just want to make sure the trial court used the appropriate law and did not misapply that law. The appellate courts keep a record. There is a transcript. And you can appeal an appellate court decision. You appeal it to the state Supreme Court. Okay, Supreme Court is the highest court in the state. They hear the appeals of the appellate courts and certain trial courts. Sometimes a trial court will allow you to go directly to the state Supreme Court if it's an issue that needs to be determined quickly. Very rarely this happens, but it can happen. State Supreme Court, again, no new evidence. Same evidence that the trial court heard, and that's the only evidence that they are going to review. There's no testimony, no witnesses. Again, it's briefs and oral arguments. The attorneys write a brief, give the court the issues of law, and then if the court invites them, they can argue it. Okay? That's the state Supreme Court system. Now, there's the U.S. federal court system. Very similar structure, but it has its own nuances. The federal court system, again, there are special federal courts or limited jurisdictional courts. The U.S. district courts, the appellate court or U.S. Court of Appeals, and the U.S. Supreme Court. Okay? So within the federal court system, you have your special federal courts, your district courts, Court of Appeals, and the U.S. Supreme Court. Federal courts system, your special federal courts are your U.S. tax court. They're your limited jurisdictional courts, similar to your state courts. All right, your U.S. Court of Claims, cases against the United States, you have to bring your case to the U.S. Court of Claims first. Bankruptcy court, Court of International Trade. These courts have limited jurisdiction, and they will hear certain issues. They will hear certain types of cases, similar to the limited jurisdictional courts of the state court system. The U.S. tax court are only going to hear tax cases. They're not going to hear bankruptcy cases. Bankruptcy court's only going to hear bankruptcy cases. They're not going to hear tax cases. Okay? Limited jurisdiction. They only can rule on certain types of cases involving certain issues. The U.S. district courts, your trial courts, hear testimony. This is where evidence is presented. These are your courts of record. This is where the trials happen. All right, this is where the attorneys walk in with their clients and their briefcases, put their briefcases down and put on their case. They put on their witnesses. They introduce evidence. These are your U.S. district courts. If you're aggrieved or you do not feel that the U.S. district court applied the appropriate law or misapplied the law, you can appeal to the U.S. Court of Appeals. All right. They, again, like the state court, will only listen to issues of law. All right. There are 13 various Court of Appeals throughout the United States. So in New York, you go to the Second Circuit. All right, down in Lower Manhattan, and they hear appeals from U.S. courts in Connecticut, New York, nothing New Jersey, but in this area. So there are 13 circuits throughout the United States. The top court of the land is the U.S. Supreme Court. All right. They do not have to hear cases. It's up to them, the 9 judges on the Supreme Court, whether they want to take a case or not. They have the discretion to hear any case. You can petition or file a writ of certiorari, I'll never pronounce that right, to ask the court to review your case, and they can say yes or no. Most of the time, they say no. They only want to hear certain cases, a certain amount of cases every year. So if your writ is denied, you have to live with what the appellate court's decision was. Again, U.S. Supreme Court only listen to issues of law. They can no new witnesses, no new facts, only issues of law. Court decision. Just be aware when you're reading the decisions. The U.S. Supreme Court can give a unanimous decision. That means all the justices ruled in one way, in your favor or against you. Majority decisions. That means that at least 5 of the judges ruled a certain way, and that becomes the law of the land. Then there's plurality decisions. That means 3 judges went one way, 3 judges went one way, and 3 judges went one way, and now we just got confusion. It happens rarely. And then there are concurring decisions. What this means is there's a majority, but one judge wrote his own opinion because he agreed with the outcome, but he didn't agree with the logic to get there. So they write their own opinion. I agree with you, but I think you went about it the wrong way, type of thing. And then there are dissenting opinions. That's when you're on the losing side and you write an opinion saying, well, this is why they're wrong. This is why I'm right. They may have the majority, but I don't agree with them, and this is why. Okay? It's the end of Chapter 2 for this week. Please review Chapter 2. We're going to have a quiz on Friday. I'll open up the quiz on Friday and keep it open through Saturday. All right? So the quiz will be on Chapters 1 and 2. The quiz will be multiple choice, true and false, some short answer, some fill in the blank. About 25, 30 questions. It'll be on Chapters 1 and 2. If you have any questions, any concerns, please feel free to contact me. I know some of you have. Please feel free. If you want to text me, call me, email me, whatever, about anything about the course so far or the quiz, please feel free to do so. Take care. And remember, quiz opening up on Friday, closing on Saturday. You need to take it. Thank you.